Hey everybody, welcome to another episode of Foreclosure Help 777, where we talk about everything foreclosure related. Today we're going to give an update on someone's case that's getting pretty interesting, and I know you guys are going to want to hear about it, so let's take a look. Let's see here. Okay, so this is a case out of Virginia, Lisa Spangler versus U.S. Bank. And if you want to look it up on Pacer, guys, the case number right here, 724CV00835. Spangler versus U.S. Bank Trust Company. And as you can see, the first entry is a notice of removal that was entered on November of 2024. Basically, she filed a complaint in the state court in Roanoke, Virginia, and they removed it to federal court, as you can see right here. They filed an answer on 12/2/2024, and then on 12/4, they filed a motion to dismiss for failure to state a claim. And then she filed a opposition to their motion to dismiss on 12/23/24, and they filed a reply motion on 1/6/2025. And then on 4/24/2025, the magistrate judge, issued what's called a report and recommendation. Let's take a look at that real quick. Okay, if you know about reports and recommendations, they're basically made by magistrate judges, and they recommend certain things to the main judge, and then the main judge actually rules. In this case, they're going over the complaint. She basically they go over and they say that they're recommending granting the motion to dismiss, and granting in part and denying in part Select Portfolio Services and U.S. Bank's motion for judgment on the pleadings. And if you skip through a lot of this stuff, which a lot of it is just, they say the weaknesses on both sides and the strengths of both sides, etc., etc. If you go all the way to the end where it's interesting, because sometimes you just want to get to the root of what's going on here. If you look at the end, it says all the counts in her complaint, all her cause of action. They go through each one. So we can go through this because this is what's important. Surviving a motion to dismiss is important for us, guys, because if we can survive a motion to dismiss, we can proceed through to discovery. And discovery is where you're going to find a lot of things that can help you win your case. So it says here that she recommends granting in part and denying in part Select Portfolio Services, or SPS, and U.S. Bank's motion for judgment on the pleadings, and granting Rosenberg's motion to dismiss in its entirety. So the FDCPA was the first one, and they're saying that they want to dismiss claims under 1692E and G without prejudice for failing to state a claim, dismiss claims for 1692D without prejudice for failing to state a claim, and permit claim under 15 U.S.C. 1692D against Select Portfolio Services to proceed. And that's kind of the whole key thing right there. Permit claim under 15 U.S.C. 1692D against SPS to proceed. Select Portfolio Services is a debt collector and is liable to the FDCPA. And that's one that she won out of all of them. The rest of them are either dismissed with prejudice or without prejudice. So that's basically what's happening with this, is breach of contract, was also dismissed without prejudice. A lot of these were dismissed without prejudice, so that's interesting. And her quiet title was dismissed again because it's saying that she didn't state her claim right. So what is she going to do at this point? Well, let's talk about what she can do at this point. And I think her best option is to amend her complaint. So let's look at what that would look like. All right, leave to file an amended complaint. Okay, so if she's going to file an amended complaint, she has to give a background section right here. So the first part says that comes now plaintiff Lisa Spangler, pro se, respectfully moves this court for leave to file a First Amendment complaint pursuant to Federal Rule of Civil Procedure 15A. In support of this motion, plaintiff states the following. On October 25, 2024, plaintiff filed her complaint in the Roanoke County Circuit Court under this case number, asserting claims related to the validity of the foreclosure process, including but not limited to a quiet title action. On November 27, 2024, defendants removed this case to federal court. On December 2, 2024, defendants filed their answer. On December 4, 2024, defendants filed a motion to dismiss for failing to state a claim. On December 23, 2024, plaintiff filed an opposition to the motion to dismiss. On January 6, 2025, defendants filed a reply in support of their motion. On April 24, 2025, Magistrate Judge C. Kalani Memmer issued a report and recommendation. The report and recommendation recommends dismissal of several claims, some without prejudice, others with prejudice. Since filing the original complaint, the plaintiff has discovered significant new facts concerning the defective assignment of the mortgage and the invalidity of the note transfer. These facts directly impact the legitimacy of the defendant's claimed interest in the subject property and their standing to conduct a non-judicial foreclosure. New facts. The assignment of the mortgage at issue in this case is dated June 27, 2014, was executed by Katasha R. Gilbert, purportedly as Vice President of Irwin Union Bank and Trust. Irwin Union Bank and Trust was closed by the FDIC on September 18, 2009, long before the assignment was executed, and as such, the assignment was executed by an entity that no longer existed. Additionally, Katasha R. Gilbert has been identified in other mortgage assignments as holding a similar title with various other financial institutions, including J.P. Morgan Chase, raising questions about the authority of her actions in executing the assignment. As a result, the assignment is void and the defendants do not have legal standing to enforce the mortgage or proceed with a non-judicial foreclosure. Legal standard for amendment. Federal Rule of Civil Procedure 15A2 provides that a party may amend its pleading with court's leave, and leave should be freely given when justice so requires. The purpose of the rule is to facilitate decisions on the merits of the claims rather than procedural technicalities, particularly where the amendment is based on newly discovered facts, as in the case here. Proposed amended complaint. Plaintiff has prepared a First Amendment complaint which includes the newly discovered facts regarding the invalid assignment and adds claims related to fraudulent assignment and declaratory judgment. The First Amendment complaint also includes additional factual allegations regarding the invalidity of the assignment and seeks to quiet title by challenging the defendant's ownership claim of standing to foreclose. No prejudice to defendants. Defendants will not be prejudiced by the proposed amendment as the new claims are based on facts and have only recently come to light. The addition of these claims is not expected to require significant additional discovery and will assist the court in resolving the dispute on the merits. Addressing the Magistrate Judge's R&R. On April 24, 2025, the Magistrate Judge C. Kalani Memmer issued a report and recommendation recommending dismissal of several claims, including plaintiff's quiet title action, on the basis that plaintiff failed to sufficiently allege the non-existence of U.S. Bank and the invalidity of the assignment. Plaintiff respectfully submits that the proposed First Amendment complaint addresses these deficiencies by including specific newly uncovered facts showing that the assignment of mortgage was executed by a purported vice president of a bank that had ceased to exist more than 4 years prior, and that the signer had appeared in similar roles for other unrelated banks, raising some serious questions of authority and fraud. These facts go directly to the heart of the issues raised in the R&R and provide a more concrete basis for plaintiff's claims, particularly those regarding standing to foreclose and clout on title. Conclusion. Wherefore, plaintiff respectfully requests that the court grant her motion for leave to file the attached First Amendment complaint and for such other and further relief as the court may deem just and proper. Okay, so that's her leave to file the amended complaint, and she will attach a good amended complaint. Okay, so the first thing we're going to look at is the promissory note. As you can see, it says note at the top, and this is the promissory note. And if you scroll down to the end where it should be endorsed by the bank, it is blank. There's nothing there. And you can see it even says this space is intentionally left blank. Oh, what do we have here? Okay, so that's release assigned. That's where the actual endorsement by the people that, you know, got the loan are. But there's no endorsement by any bank. It's blank, completely blank. Usually they have a stamp that says pay to the order of and by the originating bank. And again, the originating bank doesn't exist anymore, as you can see here. Irwin Union Bank and Trust. And they did go under. And you can Google it if you don't believe me, but I'm telling you, it went under. Now let's look at the next thing, the assignment. As you can see on the assignment, the vice president of Irwin Union Bank and Trust Company, well, MERS as nominee, is Katasha Gilbert, R. Gilbert. And the date of this assignment is 2014. So what's with this person, and why is this a big thing? Because she's a robo-signer, that's why. Let's look at some other ones. If you Google her name, you'll find her in lots of places. The actual law firm, Pearson and Patterson, LLP, is on the upper left corner of this assignment, and it says on this one that she works for J.P. Morgan Chase Bank National Association as attorney-in-fact for the FDIC for Washington Mutual Bank. And then if you look down here, the next one that we found, well, where is it? It's on this one. Oh yeah, right here. Sorry. She works for J.P. Morgan Chase Bank National Association, according to this. And then if you look at the next one, it's on the second page. She works as MetLife Bank National Association, also known as MetLife Home Loans, a division of MetLife NA by its attorney-in-fact, J.P. Morgan Chase Bank National Association. So, you know, it's a good indication by when you find all these that she probably works for Chase. So guess what? We look in LinkedIn. There she is. And guess what? She works for J.P. Morgan Chase and Company. Look at that. And it tells you what her actual title is. Operational Senior Specialist 1. And she's worked there for how long? She works there now. She's worked there for 13 years and 3 months. So, guys, I mean, you can see how she can't, you know, be in all these. She's actually robo-signing as J.P. Morgan Chase, but she, for some reason, is on Lisa Spangler's assignment. But she doesn't say that she works for J.P. Morgan Chase Bank here, which is, you know, she's in 2014. She worked for J.P. Morgan Chase, as we know. So this again, it could be that somebody used her signature and forged it. We don't know, but it's definitely proof of fraud right here. So anyway, I thought you guys would think that's interesting. The note is blank, it's not endorsed, and the assignment is fraudulent. The bank didn't exist in 2014, and the person signing off for the bank doesn't really work for that bank. So, I mean, those are two big things. So she's going to amend her complaint, and she's going to argue these things and hopefully do better on her amended complaint. So guys, as always, thank you for watching my videos. And if you subscribe, thank you very much. And if anyone has any questions, you can send me an email to foreclosurehelp777@gmail.com. It's spelled just like this with the number 4. And you can send me a question and I'll try to answer your question. Or you can join me on my private Facebook group where we talk about everything foreclosure related and help each other out. Okay, guys, I hope everyone has a blessed day.